Hi guys, I'm sorry we have to do it this way. Always bothers me to do this, but I'm trying my best to get you the information. And we're on like day 4 of nothing. We have no internet, no telephones. It's so quiet here, the phone not ringing. We don't have TV, we don't have anything because it's all just destroyed by someone. So, and we have like people digging up the streets everywhere trying to figure out how to fix this. So it's a nightmare. It's part of what happens when you live out in the end of the universe, but it's also it's the utter stupidity and our total reliance on the internet, and of course the cell phones, uh, they're not working as well either because everybody's using them. So the towers are kind of overflowed. So it's kind of getting crazy. So this week we're going to look at the law. Our discussion is summative. Uh, Tell me what you thought. Tell me what you liked. Tell me what you didn't like. Tell me what you think we could do. I would love to do more math with you, more of these calculations. But again, that would be like a whole nother class, just doing the calcs. Your homework this week is actually a calculation. So please remember that because you're going to do the present value of lost wages. There is an example of the homework problem like 3 pages before it. There's a comprehensive example that shows you how to calculate the columns and everything. And I will do a little video for you on that because I have to do that off of the actual book, which is online. So I will do that and post it up separate. So what are we going to do? We're going to look at the legal environment that we're in. And it is necessary for us because that's where we live. Forensics and fraud is all about the law, okay? It's all about the rule of law. It's all about following the procedural law, right? And law is there to solve disputes, which is awesomely what we're doing. It's what we're doing, protecting property, right? And enforcement by sanction. And those sanctions can be a million different kinds depending upon the type of law we're talking about. Law itself breaks out into civil justice, criminal justice, personal justice, social justice, substantial justice. Justice based upon our Constitution, which promises us justice. So, but we break our law out in many, many, many different categories. The first main one is public law, which regulates what goes on between us and the state, right? Criminal law, constitutional law, administrative law. We tend to deal in criminal law and administrative law. We don't tend to deal in constitutional law. Constitutional law can be awfully theoretical most of the time. That doesn't mean that it can't be, and that we can't be brought to a constitutional uh, trials. When we deal with constitutional law, you're dealing with theories and calculation of damages on the overall, which is massive. You know, uh, and you're dealing with constitutional issues such as freedom of speech, freedom of press, those kind of things, where you can calculate damages based upon what has been done to you. A restriction of your freedoms results in a damage. Whether that damage is calculable dollar wise is often the case. Banning a book costs the author. So there are constitutional challenges that can be done. Private law regulates between the individual and entities within a state. It's generally between people. All right. Private law is usually under state statute, and that's the contract law, the tort law, partnership law. We deal a lot in private law. We also deal a lot in criminal law and administrative law. Like I said, constitutional law is unique. It's special. If you ever get a constitutional case, it is an absolute magnificent thing to have. It's because it's fascinating. Constitutional law is the prime part of my dissertation, in my law dissertation. So I love constitutional law because it's in many ways interpretive, but it's interpreted into statute. It's those things that the Constitution gives us, and what it says in 5 words becomes entire books of law. It's an absolutely incredible thing to watch when you see the movement from it. But most of our cases deal with frauds, right, and issues with partnership law and corporate law and issues in criminal practice. State courts handle most of everything, right? And then they're governed by the Constitution, but also the state constitution, the state laws. They can handle most fraud cases, and most fraud cases start in state, unless we're in an interstate or an issue that is beyond the bounds of the state. Remember that you have to have standing to enter a court. So, who you are depends on what court you can get into. Lower level trial courts handle misdemeanors, the pretrial issues, and amounts below $10,000. Okay. They also have special courts: the housing courts, the small claims courts, the probate courts. Lower courts at the state level and the federal level are basically the same. They handle smaller things. Then you move to higher level trial courts. And those are the trial courts that handle everything above 10 grand and more serious crimes than the lower level courts handle. And that works the same. It mirrors in the federal system as well. You have the bottom court, you have the second court, which is the main trial court. It's the second court, right? Then you have the first level of appellate, all right? So if you're not satisfied with the outcome, you can appeal to the appellate court. There are higher and lower appellate courts, and decisions at the high appellate court are final. States have an appellate court, and then they have a Supreme Court. The United States government has appellate courts, and then we have Supreme Court. Supreme Court in the state and Supreme Court federally are the final courts of appeal. You can appeal a state Supreme Court decision to the Supreme Court of the United States, but, and there's a big but, they have to have standing to look at it. It has to be about something that they have the right to make a decision about. All right, you can't just say I don't like that law, and but it's a state law. Now, if you want to challenge the constitutionality of a law, yeah, you can go to the federal courts, and that's what you're generally doing. If you jump from state to federal, you're appealing the constitutionality of the law in most cases, because the Supreme Court in both cases, state and federal, has the right to just not look at it. They only choose what they want to see. They choose what they feel they can do. And appellate courts, for the most case, are either looking at procedural issues that gone wrong or a misapplication of the law in and of itself. Law on the merit, misapplication of the law. Right? They're not going to retry the facts of the case under the same standard. No, that's not what they're doing. They're looking at it either for mistakes, basically, in what was applied. And when you read the opinions, and we have a lot of Supreme Court opinions that come out now, but when you read the opinions, you can see that it's generally a misapplication of the law that they're looking at. And that's important because that's what they do. No, that law didn't mean that. And so, and it takes years to get to that level. So here's the organization of state courts, and you can see we have lots of lower courts, the criminal courts, the traffic courts. Then we have the higher courts. Then we have our review courts, and then we have our appellate court, which is usually the Supreme Court. Federal courts handle U.S. Constitution or federal law, right? They also handle court cases that involve multiple states or differences of opinion in multiple states, because there is no, unless it's contract law where it states where the law has to be, when there's an argument between states, it's got to go up to the top. They also include bankruptcy courts and tax court, which of course is a federal system. If you're involved in federal statutes, the fraud cases go in a federal court. I spent more time in federal court than state court when it comes to fraud cases. Most of them are under securities, banking, or RICO. That's most of the stuff I've done in my life is that, and antitrust and things like that, which are securities laws. So those are federal laws. And so they're tried in the federal district courts. And so that's where I've spent most of my life. I haven't been in many state courts except when I worked for the state government. But most of the work I've done is in federal courts. So that system I understand very well, right? And basically you have the courts of appeals. You have the International Trade Court. You have the U.S. Claims Court, which goes up to the U.S. Court of Appeals in the federal district. And then you have the 12 circuits. And so administrative courts, district courts, tax courts, magistrates, they all go up to the U.S. Court of Appeals by district. There's 12 courts of districts. And then they go to the Supreme Court. When the districts make different decisions on the same subject matter, it goes to the Supreme Court. There's often an argument between the districts because, California is incredibly left in its decisions. Texas is right. New York has one. The districts have different views on the law, which is fine because they have a different populace. And so their views are based upon the populace and the interpretation of the law for the populace. And so, arguing whether there is one singular interpretation of the law, I went to law school. No, there's no one singular interpretation of any law. So when there's an argument, it goes up to the Supreme Court, if the Supreme Court wants to take it. But generally, if there's a difference of opinion in the Court of Appeals on multiple cases in different districts, then the Supreme Court makes the final decision as to which one they're going to accept nationally. Understand that once it hits an appeals court, any appeals court, state, federal, once it hits an appeals court, it becomes precedent law. So once the Court of Appeals says something, any Court of Appeals, that applies to everyone below them. That's just the reality of it. And so you have to... Incoming voice call from +39 I'm sorry, the phone's ringing and I'm like, eh. Anyway, once it hits a Court of Appeals, that decision is final. All right? Unless you can appeal it up to a higher Court of Appeals. All right? So the Supreme Court. But once the Supreme Court makes it, that's precedent law. It applies to everybody that's under that court. So if the state Supreme Court says something, every court in the state has to abide by that ruling. So, and if the Supreme Court of the United States says something, every court has to abide by that ruling. That's why it's so important what a Court of Appeals does say. They create precedent. Other courts create examples, but appeals courts create precedent. So trials, general trial, comes in three basic stages. We have the plead stage, which is the filing of the complaint, right? And so it's the outline of what happened and the relief that's wanted. Because you file a court case, there's relief. You got to have something you want to get out of it. Otherwise, there's no reason to file the case. Just to say that someone did something doesn't, unless you want them to go to jail, doesn't really help you. And then the defendant has a chance now to file their response to it, right? If they don't file a response, it's usually default judgment and it's binding because you failed to respond. There are, of course, if they didn't contact you properly, all those kind of things. The second stage is discovery, and that's when everybody gathers their information, all right? It's usually the plaintiff that needs information from the defendant, but the defendant wants information from the plaintiff, especially detailed records and things like that you want that support your position. So it's the request for the production of documents, it's interviews, it's subpoenas and depositions, and it's governed by the federal rules of civil procedure when we're in civil court, okay? And discovery has to be given. Other than things that are protected by confidentiality, you have to give over the information to the other party. That's the law. If they find out that you held it back, then there are severe penalties in the court. So for us, when you're dealing with experts, the federal rules of civil procedure, these are the sections that are most important. The disclosure of the acts of the experts that are going to be testifying at trial. The limits of discovery to non-privileged information. When we work for an attorney, and we're generally hired by the attorney, not by the client. And even if the client hires you, they will rehire you by their attorney. And that's because it creates something called the work product doctrine, which means that our work becomes part of the attorney's work, and therefore it's privileged communication. Anyone who works with and for the attorney firm is privileged information. You don't have to be the attorney itself, because the attorney can't do all these things. The secretary can't do, he has a secretary to do things. But what's said to her is still privileged, because it's, you say it meaning it's going to the attorney. So that's privileged information. It limits the discovery of experts' communication with counsel. They can't get any of the talks that you've had with the attorneys. And supplemented testifying expert with any changes or additional information. Those are the major parts of the act that apply to us. The next step is the trial, and the jury is selected through something called voir dire, what I see, what I hear. Then you have opening arguments. The plaintiff presents their case first, the defendant presents their case next, closing arguments, and then a verdict. Criminal trials are a little different because they include, the possibility of incarceration for people. And they start differently because in a criminal case, the plaintiff is generally the prosecutor or the government. So it's a different set of rules for them. First thing that has to happen is the criminal complaint has to be filed. Then you get an arraignment, which is the first appearance, which is where we talk about the defendant is informed of the rights and the charges. They plead guilty or not guilty, and then we go into a bail hearing. Then we go into the discovery stage, which we talked about, the trial stage. And then afterwards, the defendant is found guilty or not guilty, we have sentencing. Sentencing doesn't happen in civil procedure. Civil procedure, we get, damages. So here I compare the two, and civil law is private law, criminal law is public law. Civil law is to resolve disputes. Criminal law is to convict and punish offenders. So the great big difference. The objective in a civil trial is compensation or deterrence, and the objective in a criminal law is punishment, deterrence, rehab, and protection of the welfare of the state. It's a nice way of putting it, but the plaintiff files in civil law, the government files in criminal law. The responding party is always the defendant. The burden of proof is always on the plaintiff, and the plaintiff in criminal law is the government. Now, civil law is preponderance of evidence, which is that more likely than not, very accounting concept, right? That 50% or more. In some cases, we go to clear and convincing, which is greater than preponderance of an evidence. It depends upon the court. It depends upon the act. It depends upon what we're talking about. Beyond a reasonable doubt is one of the highest, if not the highest form of proof. That's a 90% or above. And obviously, that's important because, you're talking about someone's freedom. So that's why it's so high. In states, the federal courts require unanimous verdicts in civil. States vary if it's jury trial. In criminal law, it has to be a unanimous decision. In civil law, you're found liable, partially liable or whatever, but liable. In criminal law, you're found guilty. In civil law, it's damages. In criminal law, it's imprisonment. It can be fines and penalties as well, but your freedom's at stake. The rules of civil procedure apply in civil law, and the rules of criminal procedure apply in criminal law. Now, appeals. In civil law, either party can appeal. In criminal law, only the defendant can appeal. If the defendant, once you're proved guilty, you can't be tried again, double jeopardy. And so there is no appeal for the prosecution. The government can't appeal the action. So the burden of proof is on the plaintiff. Defendant is always presumed innocent. We do have alternate dispute resolutions, mediation, and arbitration. We do use them. Obviously, court cases can take a great deal of time. Now, criminal cases are much faster because there's something about due process that requires you to have a speedy trial, right? And you can actually invoke that and force them to bring you to trial quicker so that you don't have to, wait. But trials can take a long time, especially in civil court. So you can do alternative dispute. The benefit is that it is less expensive and it is faster. Generally, the attorney fees are less and everything because of the time. It's also private. The verdicts in civil cases are published, obviously, because they're precedent or usable law. Private mediation, not published, so no one knows what happened. The IRS likes private mediation. They hate going to tax court because they hate having it published because they don't want anybody to use it against them in the future. That's where you get a lot of private letters in the IRS. They'll do a lot of private letters which apply only to the company that they dealt with. And even though they're published, and even though there is a place now where they actually have finally a database of them, you can't use them as demand from the IRS. But you can use them as a basis of your own argument without necessarily referring to them. It kind of but it gives you a good idea of what can be done. So these are the ascending levels of proof. We have a claim, we have possibility, we have plausibility. Over 50%, we have preponderance of the evidence. 70% about is clear and convincing, and 90% is beyond a reasonable doubt. Now, the court is the gatekeeper. The judge himself gets to decide most of everything that has to do with any type of evidence that's entered in. Right? So, in a courtroom, opinion is discouraged. Hearsay is excluded. And the rules of evidence govern everything. And we generally all follow the federal rules of evidence. And so when, how, and for what purpose that evidence is put in is what the judge will look at before he determines whether that evidence is acceptable. So evidence is something that proves or disproves a fact. That's what it's supposed to do, right? And it has to be relevant. And it has to make that fact more probable or less probable. Depends on which side you're sitting on. But it has to be of consequence to the people making decision. It has to have what we call probative value. That is sufficiently useful to help in examining this concept. If it's not useful, then it's not probative. And, incentive in citing evidence, we try to avoid. And often they have to weigh the difference between evidence that might be damaging to the character of a person versus the probative value of it. And the one who makes that decision is the judge. They decide whether the evidence has value or not. Of course, that decision is an appealable decision. It's like videotapes when you talk about, things that prove that someone was a horrible person or that they beat their wife or stuff like that, and the judge says that doesn't count here, even though, this is a violent act that they committed now. That is an appealable thing. If they let it in, if the judge lets it in, then the defendant can appeal it later if they're found guilty. A lay fact is a basic fact. It's a witness, okay? Everything in a court has to be entered by a witness. So, lady gets up and says, I saw him walk across the street, and how did you see him? What was the time of day? Blah, 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 blah. Those are lay facts, okay? Experts have, because of the experience and stuff like that, they're there to make everybody understand concepts, right? You're there to explain something to the judge and the jury. That's your purpose. And because that's your purpose, you're given a little bit more leeway than a layperson. And your opinion is considered much more factual. Your expert opinion is considered to be important. right? It means that you're bringing together not just simple lay evidence, but also it's been examined through some process. So Rule 702 allows testimony if it's of assistance to the facts in the case. 703 has latitude toward the expert witness. We're allowed to use a little bit of opinion and a little bit of latitude in how we present. And 704 allows us to testify areas decided by the fact finder. In other words, what the judge says we're allowed to testify about. And Rule 705 allows us to state an opinion without first testifying. So we can state our opinion up front and move on from that to support it. But there are challenges to us, okay? The Fry standard is the test for admitting testimony, whether the expert's testimony will assist the trier of fact in determining the evidence, whether the theories or techniques that are used are generally accepted and relevant professional community. You don't want to use methodologies, mathematical calculations that are not acceptable. And so it takes a long time for certain types of testing to get accepted. DNA took a while, right? It takes a while. There's a process to make something to become generally accepted. And also about the qualifications, whether you're qualified to testify. And again, those decisions are made by the judge. The judge is the gatekeeper, and they decide whether your testimony will help, whether you're qualified as an expert in the field because of skills and knowledge. Just because you're a CPA doesn't make you qualified to testify on every topic. There's special skills, special areas, special certifications make you an expert. And that you also have to prove to the judge that your testimony is based on data and facts and reliable principles and methods that have been applied. So when we talk about calculating the present value of someone's lost wages, there are methodologies that are accepted in the calculation. And so those methods have to be used. You can't just use some new method and expect them to accept it. They're not going to. The Daubert charge is based on the Daubert versus Dow, okay? And the federal court trials have the responsibility to ensure that scientific testimony is not only relevant, but reliable. Daubert means that the judge must know that what you're doing is reliable, that the scientific evidence that you're presenting is reliable. Think about DNA, and think about how difficult it was to get DNA entered into courtrooms because they needed to prove in the end that it was reliable, and it takes a long time to prove reliability of any type of process. Como is the one that is the court case that the Supreme Court gave the judge the gatekeeper obligation to all expert testimony, not just scientific. Okay, so it extended Daubert, and it gave the judge the right to reject any expert based on what's going in there. You know, they have that right to say it or nothing. Daubert, the Supreme Court gives a list of what they're supposed to look for, whether the theory or technique can be tested, whether the theory or technique has been subject to peer review and publication. And this is how you get newer techniques involved, through peer review and publication. So can it be tested? Can we actually recalc? And has it been looked at in that professional community? Do we have a known rate of error in the theory or in the calculation? Have we looked at it long enough to find a rate of error? And how widespread is it accepted? Now, new theory won't be very widespread accepted, but it could satisfy the three above and then be accepted into the court because it has been accepted and reviewed. It's been peer reviewed, it's been analyzed by the community, and it has a potential error rate, and we can recalculate and retest. And often we can test it against other theories that we've used in the past. As far as the expert goes, to qualify, you have to know the standards. You have to apply the standards to the work you've done. You have to know the literature. You have to know the recent publication. You got to know what's going on out in the world. And you have to know the organizations. You need to use generally accepted analytical methods in your calculations. You need to use multiple analytics. Triangulation if possible. 3 is the best. You have to synthesize the multiple methods into one answer. Then you have to disclose all of the assumptions. The assumptions are where we lose it. The assumptions are where they're going to come after you. All right, that's where everybody's going to come after you. And really, and honestly, one of the biggest things that you do is get someone to review all your assumptions and make sure that they are the best they can be at this moment in time. Because, assumptions like interest rates, assumptions like life expectancy, you need to support where those things came from and how reliable they are. You have to subject the analysis to peer review, which is the best thing that you can do, is have it reviewed by others, which is something you always do, at least 2 or 3 if it's possible. People who are as good as you or as qualified as you. And we have relationships between each other where we will look at each other's stuff. As long as the other person's not involved in the court case, doesn't really matter. We have a certain amount of privity between. And then test the analysis and the conclusions for reasonableness. Take a step back and look at it. Does it make sense? Does the answer make sense? Just because the answer is mathematically sound doesn't mean the answer makes sense. All right? There could be a mistake early on that makes all the other math bad. All right? So just remember that when you're doing these things. Don't get myopic. You can be obviously challenged through Daubert. And a Daubert challenge is conducted by the judge. It's to measure the validity of your opinion. And it looks at those questions that the judge was supposed to ask. And either party can enter a Daubert challenge against experts. That's all there is to it. Anybody can challenge. Anybody on the other side can ask the judge to challenge someone's expert. Be careful when you challenge expert classifications, though, because if you challenge them, then obviously the other side will start challenging. Experts can be just accepted in to the court by who they are. But be careful when you challenge. You don't want to upset too many people. The other thing we have is privileged communication. As long as we're working with the attorney, we are subject to the attorney-client privilege, right? There are only 2 states, I think, in the United States that have CPA client privilege. Florida is one. I practice in Florida, so it works like attorney-client privilege, and it can't be broken without a subpoena. Whereas attorney-client privilege cannot be broken at all. And so generally the attorney hires you. And so the work that you do is covered by the work product doctrine, which means all your work is protected under his attorney-client privilege. All your communications are protected. You can talk to the client as much as you want. You don't want to, if you've been hired by the client, you don't want to talk to them, because anything they say, people can elicit from you in a courtroom. So in general, if you were originally hired by the client, you are then rehired by their attorney, so that everything you do falls under that privilege. And obviously, you want a good relationship with the counsel. You want to talk to them a lot, keep them up to date, them keep you up to date. Respect, responsiveness, and ethics, always. When you testify, you want to communicate the truth to the jury in an ethical, objective, and effective way. Maintain your autonomy, your authenticity, and your integrity. Uphold the values of the profession. You're not an advocate. You're a witness. And you're an expert witness at that. Your only purpose is to enter fact, not to advocate for the witness, for the person or whoever. You're not there to tear apart a defendant. If you're working for the prosecution, you're not there to like support the defense. You're there to speak the truth. That's your job. Becoming unbiased is the worst thing that you can do. It will get your testimony thrown out. You interact with everybody with respect. Your purpose is to make complex things simpler. Your purpose is to make them understand. Your purpose is to make them understand the value of a person's life sometimes. But you're doing it mathematically, and so you have to explain what is taken into consideration when it happens. So we take into consideration their lifelong income. We take into consideration all the benefits they would have gotten from their company. That we take into consideration the pension that they didn't receive. We take into consideration a lot of things when we try to figure out the value. We take into consideration household costs, household duties. You know, if the mother dies, who's going to cook, who's going to clean? And I know that's very that's very sexist right there. But if any parent dies, right? If you lose a parent in an accident, either parent, there are a lot of household duties that they would have done, that they would have shared, that now you have to hire someone to do. So that becomes part of the cost of the value of someone's life. You know, those are the things we can quantify. We can't quantify everything else, but we can quantify a number of things, right? And that's the terrible part, is that we can't quantify everything. Obviously, the loss of a human life is uncalculable in many ways, but we've had to make it calculable. And you're there to explain it in a very simple but meaningful way, not to diminish the number, not to lessen the theory, but to make it understandable to the best that you possibly can to the people that you're speaking to. You do have immunity as a witness. The threat, they can't sue you. You can't be claimed negligent just for testifying. You can be sued for real negligence, right? Basis is for liability if you have real negligence in the work you've done. There can be, or breach of contract, which is generally speaking outside of the lawyers, but in general, you know, they just can't sue you because they want to. And here it is, some of the best ways, some of the good things. Antitrust law. Antitrust law is fun. Antitrust law is proving that someone is or isn't a predator in the market, all right? It's about determining whether a monopoly is a monopoly, or whether someone's trying to make a monopoly, or whether someone's trying to destroy all their competition, right? So what we're called upon to do is determine whether someone has engaged in predatory pricing. We can do it from either side. Obviously, we can protect the defendant who has been charged with predatory pricing, or prove that they are for the prosecution, one or the other. But it's about cost accounting, and using cost accounting to figure out what the actual cost of a thing is, the variable cost, and whether they're selling it below their average variable cost. So that's the definition of predatory pricing when it's present. But predatory pricing is designed to put people out of business. And so that's one of the big issues when we talk about this type of lawsuit. They're awful fun to work on. And we use high-low methods. We use regression analysis. We use linear regression. We use a lot of statistics when we're looking at cost behavior and cost history. All right. And not only their cost history, but others within the industry. But you can show their cost history and when they've started to lower it, and how they've done that, and what that effect has been on others around them. We can use other methodologies, the coefficient of correlation, determination, non-determination, movements in the independent variables, reasons for the unexpected. When we look at the association between the price, selling price, and cost, you know, the causation and analysis, we use math. There's a lot of math to show the correlation between the change in price versus the cost, and what's going on in the outside world. That they're lowering their cost, they're lowering their price, and this is the typical price out in the market. This is their price out in the market, and you can watch it lower versus the cost of goods. And even without their cost, we can see what the cost of goods for the averages through industry averages, and we can also look at we can compare that to inflationary changes and changes in the price of materials and labor and all those kind of things, and show where the variable costs would be leveling or rising while they're dropping their costs, they're dropping their sales price and things like that. So you can show their intention in some way or another. Other things is allocations, transfer prices. Allocations and transfer prices change massively income, and they're often part of what we're looking at is that they've just made full-on transfer prices from another company. So they have it produced in one company, they transfer it to a title company, and then they transfer it back out, all subsidiaries of the main company. And so they can reduce the cost of the item that way. And that's not the real cost, but they can reduce it by selling it to a subsidiary for less than the cost, or transferring it to a subsidiary for less than the cost. And now they've dropped the cost below everybody else's cost. Okay, so that's one way of doing it. Or they can allocate their overhead in a different way. They can use throughput pricing, which is just variable pricing of only materials. And so they can use throughput pricing and make the cost of their inventory minimal. It doesn't include any labor, doesn't include any overhead, and use that as their variable cost for justifying their sales price. When in essence it's not. It's still at a loss. So you can look at those kind of things. Another one is the False Claims Act. And the False Claims Act, in most cases, when you're dealing with this, is government contracts. And you're examining government contracts for them, defrauding the government, for overcharging for goods and services. There's usually an allegation. It's usually done through a whistleblower. And, which gives us our reasons for action. Okay? That's our predication for doing the work, because they generally need predication to start these things. But we can be for the defense or the government or the whistleblower in litigating the quid tam parts of the case. And basically, you're looking at what the cost should be, how should the cost be measured. There are governing rules for government contracts, and then each contract may have specific ruling within it. But there are general rules for contracting with the government that are produced by the GAO, and so you can look at the cost methodologies that the GAO accepts and compare them to the cost methodology that the company is using, what their rules are, what's the magnitude of the damage that occurred. You try to figure out the difference and the magnitude of what they've overcharged the government. And you also have to prove that intent thing, remember? For it to be a crime, it must prove intent. So somewhere in there, you have to prove that they knew what the data was. They knew that the information was wrong. Whether, but plausible deniability. But you have to prove that they knew it, or that they acted in reckless disregard for the truth. That they knew what was going on. They applied the standards the way they did on purpose. That's intent. That allows it to be charged as a crime. After all of that, we have to write a report. No matter what we do, we write a report. Okay. They can conclude in the report of investigation. It's a formal written report. It's often sent to police and insurance companies. When you do a private fraud examination for any entity, it's usually because they need it for their insurance, and they need it for the police. So you can set the damages for the police. I mean, you can't. It's hard to prosecute somebody. Even a lot of companies like us don't prosecute, but it's hard to prosecute somebody if you don't know the amount that you want back. Right? Really hard. And insurance companies want approximate damages, and they have their own people too as well. But insurance companies want approximate damages, so that they can pay out. It must be accurate and understandable. It conveys the evidence. It adds credibility. It accompanies the objective of the case. Please. It accomplishes everything that you're supposed to do. It looks at what you intended to do. And it's written with the reader in mind, which in most cases is civil and criminal trial. So you write it in a form that would be acceptable to the court. You state the facts. You don't make errors, which means you have it reviewed multiple times. And you include a follow-up section. There's always a follow-up section. Court cases take forever. And so you do follow up your findings over time before the case gets into the courtroom. Its format is much like an internal audit report. That's a really good format to use, is the internal audit report, which is based upon the APA, which is why you learn APA. It's based upon the APA research paper, which gives you an upfront summary, right, which would be like your abstract, right, upfront summary, the introduction and the purpose, the body, which includes everything that you intend to do, and then the results, what you found. Results are facts. This is what I examined 397 invoices. Of that, 232 were approved by this person. Of those 232 invoices that she approved, 97 were to a fictitious company. This is fact. This is just fact. Okay? And then we reviewed invoices approved by a second person as a mitigator, and that person approved 397, and of them 0 were to. So fact only. Then we have recommendations and follow-up, which is the interpretation. Okay, but it's fact. Opinion does not come into it. Opinion comes from it. All right, we generally don't have an opinion in the report. We generally don't. Okay, we have recommendations, what they should do to prevent it from happening again, or what they should do, to deal with the situation, and then follow up anything that we've come to help them with their internal controls but opinion we don't include. We don't say that we believe this person committed the crime. We don't say that ever in our report. Now, they may ask you on the stand, what is your professional opinion? That's when, the report supports your professional opinion, but it's not put in there, okay? It's just not written in there. That's the reality of a forensic report. A forensic report is the facts, and only the facts. All right, guys, that's it for this one. And I will do one for you for homework and upload that as well. I will see you in class.